Good morning. I'm Judge Jackie Powell, and we're in first appearance court this morning. Today, I am going to tell you whether I have found probable cause, and then will also talk about release conditions. Today is not your trial date, so today you will not talk about your case, and I advise you not to talk about your case because everything in this courtroom is being recorded. If you have an attorney at the time when I call you up, your attorney will speak on your behalf, and if there's something that you are pressed to let the court know, you can let your attorney know what it is before you speak on the record. I'm going to call everyone individually, so when I call you up, I'm going to ask you to come up to the podium, and then we will address your case individually. So this morning, we are going to start with the domestic violence docket and Roshimia Peterson.
Your Honor, Ms.
Hello,
Peterson
Your Honor.
is
Broward.
in North Broward.
She
has private counsel whom I'm trying to reach. If we could recall that, please.
Okay, so I'll recall the case. You were trying to call the private attorney, is that what you said, Mr. Reedy?
Yes, I am, Judge.
Oh, okay, all right. Ms. Peterson will recall your case. We're trying to locate your attorney, okay?
Okay.
All right.
Go ahead back in and so on.
So, Antonio Stubbs Huff.
Judge, he's here present. Huh? Oh, Judge, if we could put him on brief recall. Initially, this gentleman declined, and now he wants me to assist him, so I need a little bit to talk to him, Judge.
Okay, no problem.
Thank you, Judge.
All right, can we do Robeson Nelfrard?
Yes, Judge, he's here. He's approaching, Judge.
Mr. Nelfrard, you're before the court this morning for one count of touch or strike battery, and the court does find probable cause.
Good morning, Your Honor. Anna Lopez on behalf of the state.
Good morning, Ms. Lopez.
Good morning. The state would ask in this case for a bond of $3,000, given the fact that the battery occurred in front of the children and the 2-year-old daughter was being held by the victim when the victim was battered. He also has a 2016 DUI and a 2012 driving while license suspended.
Okay, I do find probable cause. I am going to impose a bond of $3,000. No victim contact until further order of the court. Good luck, sir.
Good luck, sir.
Lincoln Hanley.
Mr. Hanley is approaching, Judge.
Mr. Hanley, you're before the court for one count of touch or strike battery. And the court does find probable cause. I will hear from the parties as to bond.
Your Honor, Kesha Davidson from the state. Good morning. The state will be asking for $1,000 bond, Your Honor.
All right.
Judge, at this time, nothing to add by the defense. That's reasonable.
Okay. I will impose a $1,000 bond. No contact. Okay, sir, good luck. No contact with the alleged victim in this case until further order of the court. Rafael Nieves?
He's approaching, Judge. I mean.
Sir, you're before the court for a violation of injunction of protective order.
Your Honor, the state is asking for a
That's okay, no problem. I do find probable cause. You may go ahead.
The state is asking for a $5,000 bond, given the fact that the defendant was found guilty of second-degree murder, dangerous act, and he was released in 2008. He was sentenced to 35 years. Also, the state would like to ask for a level 2 GPS, Your Honor, given the fact that he did, in fact, go to a location he was not permitted to it. And the state also provided a petition to the court, Your Honor. So to clarify, the state is asking for a $5,000 bond given his criminal history and a GPS given to the fact that the defendant went to a location he was told not to attend.
Judge, at this time in speaking, Mr. Nieves, I don't think he's quite going to be able to afford the monetary aspect as far as what the state is recommending. We're going to be asking for the court to consider setting a $1,500 bond. Now, Mr. Nieves is working, he's self-employed. He basically clears liens on properties. And on a good week, he can make up to a $400 per week. So as you can see, financially, he's not going to be able to afford what the state is suggesting. Now, because of his employment, Judge, he goes out to different locations. So it's not like on a GPS monitor where you have to give pre-trial your schedule ahead of time. That's going to impede him from being able to work. Now, we don't mind as far as at this time him being supervised by regular pre-trial release, but we're asking the court to consider a $1,500 bond on his behalf. Now, he is advising me, he's from his conversations with law enforcement, he believes the nature of the violation was a text message, not actual a physical contact or having any sort of contact with the victim as far as physically. It's a text message, so this comes as a surprise to him, and he's contesting this allegation as far as the injunction, but we're requesting for and standard pretrial release, Judge.
All right, I'm sorry?
He can actually place on a GPS monitor with an open schedule, and it will still keep him away from the victim,
I know.
but he doesn't have to.
You're talking about, yeah, I know, thank you. Standard pretrial is going to be denied. I do find probable cause. The facts are a little bit different, Mr. Romero, from what your client has told you that's alleged in the affidavit provided to me. So I will impose a bond of $2,500, and I am going to put him on the GPS monitor.
Judge, my understanding also, one other issue as far as the GPS, I don't know if there's a foot requirement. My understanding is where Mr. Nieves lives, to his knowledge, I guess his ex-wife just moved to an area which is now about 1 block away from Mr. Nieves. So I believe his ex-wife actually moved to a location closer to Mr. Nieves. I don't want that to impede his ability from being able to be on a GPS monitor.
Well, I'm going to leave the GPS monitor in place. He can address that at a later time if there is an issue. No victim contact and $2,500 bond.
And just a last request, a phone order, please.
Yes.
Thank you.
Thank you. Roxanne Sutherland.
She's approaching, Judge. She's here at Maine. Come on up, ma'am.
Were you arrested by yourself? Do you have any children?
All right, Ms. Sutherland, I've been presented with a PC affidavit that says count 1 is aggravated assault with a deadly weapon. Count 2's touch or strike battery. Counts 3 through 5 are neglect child without great bodily harm. This one, I did not find probable cause for count 2. I do find probable cause for counts 1, 3, 4, and 5. Does the parties wish to be heard?
Was intentional. If the court's not inclined to find PC, I understand. I would be requesting a bond in the following amounts, though. I would be requesting a $7,500 bond on count 1. bonds in the amount of $2,500 on 3, 4, and 5. I am concerned that she took these actions with the 3 children in common in the vehicle, putting their safety at risk. I would note she was arrested in 2007 for domestic violence battery against a different alleged victim. That charge was dropped.
Judge, and speaking with Sutherland, as you heard, basically she has a clean record. She lives in Fort Lauderdale. She's right now taking care of her 3 kids. She just moved into a new location, and her monthly rent is going to be $1,150. Now, she is working. She works at a nursing home where she's been employed now for about 1.5 years, only making $10 an hour. She's 33 years old, been living here in South Florida for the past 17 years. Her and the alleged victim do not live together. I did apprise Ms. Sutherland as far as typically on domestics, there's going to be no contact order with the alleged victim, and also potentially no contact with the kids until further order from a court. Ms. Sutherland is looking forward to trying to get back with her kids, to adhere to whatever condition this court imposes. Judge, considering her financial resources, I'm going to be asking for a $3,000 bond on count 1 and $500 bonds on counts 3, 4, and 5.
Okay, I do find probable cause. As to count 1, I will impose a bond of $3,000. Counts 3, 4, and 5, it will be $1,000 on each count. No contact with the victim in this case, no contact with the minor children until further order of the court, and no probable cause on count 2. Sure. What cases are we ready for this? Okay.
Spanish, yes, Judge. There's 2 gentlemen that require Spanish interpreter.
Okay, Juan.
And I believe he's next. Yeah.
Juan Perez.
Señor Perez, ven.
Thank you. Do you swear or affirm to translate from Spanish to English and English to Spanish?
I do. Esteban Rojas.
Good morning, Mr. Rojas.
Good morning.
All right. Mr. Perez,
Señor Pérez,
you're before the court this morning
usted está ante el tribunal hoy
for 1 count of battery,
acusado de un cargo de lesiones,
domestic violence.
violencia doméstica.
Count 2 is tampering in a misdemeanor proceeding.
El segundo cargo es alterar prueba en un proceso contravencional.
And counts 3 and 4 are misdemeanor capias.
Y los cargos 3 y 4 son órdenes de detención o de captura por contravenciones.
The capias matters are from 2007.
Las órdenes de captura datan del 2007.
For a DUI.
Por un DUI.
And count 2 is operating without a valid license.
Y el segundo cargo es operar sin licencia válida, operar un vehículo automotor sin licencia válida.
On the misdemeanor capias matters, there are bonds that have been imposed.
Para las órdenes de captura, para las contravenciones, hay fianzas.
Count 3 is $2,500.
El tercer cargo tiene una fianza de $2,500.
And count 4 is $500.
Y el cuarto cargo, la fianza es de $500.
As to the new charges, I do find probable cause.
Con respecto a los cargos nuevos, considero que existen indicios probables.
And I will hear from the parties as to the bond.
Y ahora voy a escuchar a las partes en lo que se refiere a la fianza.
Your Honor, on count 1, the state would be requesting a $2,500 bond.
Eso sería para el primer cargo, la fiscalía solicita una fianza de $2,500.
On count 2, a $1,500 bond.
Para el segundo cargo, $1,500.
No victim contact.
Que se le prohíba tener contacto con la supuesta víctima.
I am concerned about the level of violence.
Me preocupa el nivel de violencia desplegado.
that it allegedly occurred in front of at least in front of a child.
Y se alega que ocurrió al menos una vez delante de un niño.
According to the report, the victim felt the need to flee the home for safety.
Según lo que consta en el informe policial, la supuesta víctima tuvo que huir de la casa por temor a su seguridad, por su seguridad.
I'm also concerned about the allegation that Mr. Perez took the couple's youngest child.
También me preocupa la acusación de que el señor Pérez tomó al hijo menor de la pareja
And fled the location before law enforcement could arrive.
y huyó del sitio antes de que pudiera llegar la fuerza policial.
Judge, at this time, considering what the state said, their request on count one, $2,500 is reasonable, and count two, $1,500 is reasonable.
Su señoría, dado lo que acaba de enunciar la fiscalía, lo que se solicita en cuanto a que la fianza sea de $2,500 por el primer cargo, $1,500 para el segundo, es razonable.
The only thing we're going to be asking for is a phone order, Judge.
Lo único que solicitamos es que firme un auto permitiéndole acceso a su teléfono, señora juez.
Okay, I will sign that order.
Muy bien, voy a firmar esa orden.
I find probable cause.
Considero que existen indicios probables.
As to count one, I will impose a bond of $2,500.
En cuanto al primer cargo, voy a imponer una fianza de $2,500.
Count two will be $1,500.
El segundo cargo, $1,500.
On the capious matters, those bonds were previously imposed, as I stated before, is $2,500 and $500.
Las fianzas para las órdenes de captura, como dije anteriormente, ya están impuestas, $2,500 y $500 respectivamente.
And no victim contact until further order of the court.
Y se le ordena que no tenga contacto con la supuesta víctima hasta que se disponga lo contrario.
And I will sign the order that your attorney has requested.
Y voy a firmar la orden que su abogado me ha solicitado firmar.
Good luck, sir.
Thank you, Judge.
Buena suerte, señor.
Your Honor, if you want to recall Ms. Peterson?
Okay.
There's one more person that requires
Wait.
Spanish
All
interpretation.
right, so let's do that
Actually,
first.
there is. There's
Who is that?
We've got another one too.
Mr. Norberto on page 13 of the docket. Señor Norales.
Okay, Romel Norales Norberto.
Rommel Morales Norberto.
Yes.
Yes.
Okay, Mr. Norberto, you're before the court today for two traffic capious matters.
Señor Norberto, usted está ante este tribunal hoy por dos órdenes de captura por temas relacionados con tránsito.
Those are charges from 2010 and 2009,
Esos cargos datan del 2010 y del 2009
and both are for operating without a valid driver's license.
y ambos son por operar un vehículo automotor sin licencia válida.
I do find probable cause.
Considero que existen indicios probables.
What does he wish to do?
¿Qué desea hacer?
Judge, I'm going to be requesting, considering the date of these incidents, I believe both of them have 2009 case numbers, I'm going to be asking the court to consider an ROR on his behalf.
Su señoría, dada la fecha de estos supuestos incidentes, ambos tienen un número de expediente del 2009. Voy a solicitar que la corte considere la posibilidad de excarcelar a mi cliente bajo palabra.
And Judge, the reason why I'm asking for an ROR is he simply can't afford it. He lives in Coral Springs with his wife and kids, and he's supporting the household.
Y para aclarar la razón por la que estoy solicitando que se le libere bajo palabra, él vive con su esposa y sus hijos en Coral Springs, simplemente no puede costear una fianza.
Now he works in construction, but his financial resources are limited.
Trabaja en construcción, pero sus recursos económicos son limitados.
Now, I did advise him he signed up with the Public Defender's Office, so he'll know his future court date by one, either coming in the mail, or two, if it doesn't come in the mail, he can contact our office to find out when's his future court date.
Y sí, le expliqué que debe registrarse con la defensa pública para que se le informe directamente sobre cuál será su siguiente cita judicial o si no, que se le informe por correo.
What is Mr. Norberto's current address?
¿Cuál es la dirección actual del señor Norberto?
He Rodríguez, tu dirección.
11574 Northwest
11174 Northwest. ¿Northwest qué?
Northwest 42 Street, 42 calle Coral Spring
Northwest 42nd Street, Coral Springs,
33065.
33065.
Okay, I will ROR Mr. Norberto.
Bien, voy a concederle la excarcelación al señor Norberto.
You need to make sure that you correct your address with the clerk.
Tiene
Make
que
sure they have the right
asegurarse
address.
de que corrija o actualice su dirección con la secretaría para que tenga una dirección válida para usted,
Okay, so that you don't miss your court notice.
para que le llegue su citatorio.
All right, good luck, sir.
Buena suerte, señor.
Is there anyone else who needs a Spanish interpreter?
There is, Your Honor, one of the municipal ordinance cases in Paul Ryan requires a Spanish interpreter. I'm not sure which one of the two it is, to be honest.
Paul Ryan?
Paul Ryan, I have one.
All right, what's the name?
¿Cuál es tu nombre? Moisés. Moisés.
Moises. Is that his last name?
Garay is his last name.
What's
Moises Garay.
the last name?
Garay, Garay.
I don't remember seeing that name. Yeah?
He's on page 11, Your Honor. It's a traffic citation. And,
All right, let me try again. Start from the top. Okay, Moses Garay. All right, Mr. Garay,
Señor Garay,
you're before the court
usted está ante el tribunal
for a traffic capias matter.
Porque tiene una orden de captura por un tema de tránsito.
The charge is operating without a valid license.
El cargo es operar un vehículo automotor sin licencia válida.
And this is also a capias from 2016.
Y esta es una orden de captura que data del 2016.
What does Mr. Garay wish to do?
¿Qué desea hacer el señor Garay?
Your Honor, based on the nature of Mr. Garay's other charges,
Su señoría, dada la naturaleza de los otros cargos que pesan contra el señor Garay,
I would ask the court to leave the $50 bond in place.
Solicitaría que la corte deje en pie la fianza de $50.
I do find probable cause,
Considero que existe indicios probables
and the bond is $50.
y la fianza será de $50.
Good luck, sir.
Buena suerte, señor.
Do we have anyone else who needs a Spanish interpreter? Conte?
Not to the best of my knowledge.
North Broward? All right, Mr. Rojas, thank you.
Judge, if we could recall Miss Peterson at North Broward.
All right.
Come on, Miss Peter.
Ms. Peterson, Rashimia Peterson
Yes.
at North Broward. Okay.
Judge, I attempted to reach Miss Peterson's attorney. Unfortunately, his mailbox is full, and I was not able to leave a message. And I know that there are some concerns about getting Miss Peterson back to her cell, so I don't see that there's a real benefit to her sitting there.
Okay.
I am going to ask the court to consider a low bond for Miss Peterson. She has no prior criminal history. She has been living in the same location by herself for 1 year. She is a graduate student at FIU seeking a degree in business. She got her undergraduate degree from FIU. She's a veteran of the U.S. Army. She served from 2011 to 2014 and received an honorable discharge. I've read the probable cause affidavit, as I'm sure the court has as well, and obviously there are causes for concern. Ms. Peterson indicated to me that she feels fine now, and she is able to post a bond, although not a very high bond.
All right.
And Your Honor, the state would recommend a $2,500 bond. We're concerned regarding the potential safety of not only the defendant but the victim. We also provided, Your Honor, a copy of the petition for the injunction, where we do have concerns regarding the victim's safety and the fact that the defendant not only went to the victim's house but to her job. So we would also be asking for GPS.
Okay.
I'll apply for it.
All right, the court does recognize that there are some concerns as indicated by both the state and defense. Ms. Peterson, and I don't know what kind of help you can seek at this time, but I'm sure you can speak with your attorney in regards to that. With that said, there is concern for the community and also for your own safety. And so finding probable cause, I am going to impose a bond of $2,500, and I will also be placing you on a GPS monitor.
And I will continue to try and reach Ms. Peterson's attorney, Your Honor.
And until further order of the court, ma'am, no contact with the victim in this case. There is an injunction that's in place, and you need to abide by that injunction.
Okay.
Okay? All right, good luck.
Thank
Good luck,
you.
Ms. Peterson.
And which one?
Just a second. Let me take you back.
Judge, the domestic that was on RICO, whenever the court's ready, we're ready to proceed.
Okay. Does the state have the name of the victim on the Peterson case?
Yes, Your Honor. The name of the victim is Destiny A. Jones.
How do you spell Destiny?
D-E-S-T-I-N-Y.
Okay, got it. Jones, yes. All right, Mr. Romero, you were asking me to do what now?
Judge, the domestic, the first one on the domestic, as far as here, Maine, Mr. Stubbs Huff Antonio,
Yes.
we're ready to proceed.
All right, Antonio Stubbs Huff.
He's approaching.
Sir, you're before the court for one count of touch or strike battery, and I do find probable cause.
Your Honor, the defendant is currently being supervised by pretrial services for one count of reckless driving, one count of operating without a valid license, 191850 TC10A, placed on pretrial supervision on January 18, 2019. Based on this court's finding of probable cause, we ask that his pretrial status be revoked.
All right, yes.
Judge, I'm going to ask you at this time if the court's inclined to take action on the case that he's out on. One, I'd ask the court, I believe.
A house I can move into.
I'm sorry about that, Judge. I'm going to be, I believe he's out on standard pretrial. Rather than revoking his release and holding him no bond, which is the most severe sanction this court can impose, I'm going to be asking the court to consider releasing him on a level 2. That would be a heightened form of supervision with a monitor. That's what we're going to be requesting at this time, Judge.
All right. I am going to deny that level 2. I believe that reading the probable cause affidavit, there are some concerns. And maybe there are mental health concerns. The allegations are that he beat up on his mother, who has indicated through the allegation, through the report, that she's not able to control Mr. Stubbs Huff. So I am going to revoke the pretrial supervision as to, and I will impose a bond of $250 on each count. And then as to these new allegations, I am going to impose a bond of $2,000. No victim contact. And no return to this address until further order of the court. 4401 Southwest 36th Street in West Park, Florida.
I'm sorry,
Yes, sir.
Judge, how much bond on each count on the case you revoked?
$250.
Thank you.
Unfortunately, ordering them, there probably needs to be a mental health evaluation. Michael Parrish.
Mr. Parrish is here, our main judge approaching. Come on up, sir.
Mr. Parrish, you're before the court for one count of battery, second or subsequent offense of domestic violence. Count 2 is possession of cannabis, 20 grams or less, and count 3 is possession of drug paraphernalia. I do find probable cause. Yes. I'll hear from the parties as to bond.
Your Honor, I'm going to be requesting a $10,000 bond.
Judge, I can't hear.
I'm going to be requesting a $10,000 bond, no victim contact, pretrial release with a GPS monitor level 2. First, I would note Mr. Parrish's criminal history: 2015 burglary of a dwelling, 2013 unlawful use of false name ID, 2014 burglary of a dwelling and grand theft from a dwelling, 04 resisting without violence, 02 uttering a forged instrument, 2 counts, possession of cocaine. He violated probation, was sentenced to a year and a day state prison as a habitual offender. 2001 grand theft auto with a violation of probation, a year and a day state prison as a habitual offender. Your Honor, these are dated, but I believe they're relevant to the matter before the court at this time. 1992, aggravated battery with a deadly weapon, shooting at or throwing a deadly missile, 5-year state prison. 1987, robbery with a firearm or deadly weapon, 6-year state prison. Your Honor, I'd also want to bring to the court's attention our office has had contact with the listed victim. She's in great fear of Mr. Parrish for her own safety and well-being. She suffered injury as a result of this incident. Your Honor has read the allegations. You can see the amount of force that was used in this case literally pulled her arm out of the socket.
Judge, I understand Mr. Parrish has a record, but I do also understand, I believe from what the state was telling me and confirming with Mr. Parrish, he's been at almost 3 years clean, or over 3 years clean with no contact. He's 48 years old and living here in our community his whole entire life. At this time, he's collecting disability. He gets approximately $750 per month. He will abide by the court's order as far as no contact with the alleged victim. He'll be residing with his uncle, who lives in Fort Lauderdale now. The only person he can reach out to post a monetary bond would be his uncle. His uncle works in landscaping, so his uncle's not going to be able to afford the bond which the state is requesting. I'm going to be requesting a $1,500 bond on count 1, Judge. I understand that the state is asking also for a level 2. We're going to be asking for $1,500 plus standard pretrial. Mr. Parrish
Could
is
I
being.
say something to the judge?
Yes, but not about the facts.
No, not about the facts.
Okay.
No, man, I've been an active, productive citizen ever since I got off of probation. I don't want to state no facts about no case, about anything like that, but just the things that I be doing. I wish that the state can see my future where I'm going. I'm also a part of the Big Brothers and Fathers Association when I help the children in the community. After all of this, watch out, I'm quite sure that the truth is going to come out because I trust in God. Ma'am, I don't have a whole lot of time here. I do suffer from Hodgkin's. Uh, it's in remission. Thank God for that. I had 9 cycles of chemotherapy. And I'm doing good. And this just was a misunderstanding. The police didn't come. I got into the ambulance with my fiance, and when I got there, I explained the situation to them, and then they had me arrested. No police was never called to my house. I got in the ambulance and I went there with her because it was just a misunderstanding. She snatched away from me too. Well, I'm sorry. And that was the case, man. But I am an active part in the community. I do have a small part-time 3 hours a day job, man. I can't afford $10,000, man, but I want to apply by any rules and regulations that the court has to offer, ma'am. At this time, I just don't need to be incarcerated. I got a whole lot of things going on. I think my uncle can come up with a little bit of money, or I get $750 on the first of the month, but that's far off. And I'm just asking, for a little leniency here, ma'am. I've been out of trouble for 3 years. I can understand what I did in the past, but I can't go on what I did in the past because that's not where I'm going today, ma'am.
Your Honor, I have no idea what will happen in the future. My concern right now is the present. And I would also note, as it is explained in the report, why the victim offered one explanation of what happened, and when she wasn't around Mr. Parrish, for him to order her to explain what happened, she gave the explanation of his violence against her.
All right. Mr. Parrish, I have to make a decision based on what's in front of me today, and the allegations in this affidavit is concerning, and it is concerning also that the alleged victim did state that she had to say what you wanted her to say when she was in front of the police. So I have to take that in consideration because that's what's provided to me in this affidavit. And so based on that, I do find that a reasonable release conditions is $10,000 with a GPS monitor. No victim contact. That means no phone calls, no asking anyone to call, no emails, no writing, just no contact until further order of the court. Good luck, sir. Francisco Villatoro.
Mr. Villatoro is here at main judge approaching. Come on up, sir.
Sir, you're before the court today for 1 count of touch or strike battery. And count 2 is false imprisonment of an adult. I do find probable cause, and I will hear from the parties as to bond.
Your Honor, I'm going to be requesting a $2,500 bond on count 1, $5,000 bond on count 2 in order of no victim contact. My concern is not only that Mr. Villatoro restricted and prevented the victim from leaving the area or where this happened, but he did so by force. I would note, a moment, Your Honor. There was a previous arrest in 2016 in Dade County for felony possession of cannabis and unlawful use, display, possession of a firearm. He pled out the cannabis charge. The firearm offense was dropped.
Okay.
Judge, I'm going to be requesting a $1,000 bond on count 1, a $2,000 bond on count 2, making a total our request $3,000. Mr. Villatoro is not a convicted felon. He's been here in South Florida his whole entire life. He's 23. He is employed. He works in construction, been doing that for the past 4 years, in which he gets paid about $12.50. Now, he does have family that reside in our community that he's going to be reaching out to, specifically his mom, but from what he advised me, his mom is on disability, and she's residing in North Miami, so she's not going to be able to afford quite that much. So my understanding is he's also going to be abiding by the court's order as far as living separate and apart from the alleged victim. He's going to be residing with a friend in Hollywood.
I'm actually moving there. Forget.
Okay, so he's not have any sort of contact, Judge. So that is why we're requesting a $3,000 bond on his behalf, Judge.
All right, the court does find probable cause as to count 1. I will impose a bond of $1,000. Count 2, it'll be $2,000. No victim contact until further order of the court.
And Judge, would you sign a photo order?
And I will sign a photo order. Good luck, sir. Oh. Lascelles Anderson.
He's here, present, Judge Amin.
Mr. Anderson, you're before the court for 1 count of aggravated assault with a deadly weapon. And count 2 is battery causing bodily harm, domestic violence. I do find probable cause. I'll hear from the parties as to bond.
Thank you, Your Honor. I'm going to be requesting a $15,000 bond on count 1, $2,500 bond on count 2, an order of no victim contact, pretrial release with a GPS monitor, my concern being the allegation that Mr. Anderson pulled a gun on his sister and threatened to kill her.
Judge, I'm going to be asking for the court to consider setting a $5,000 bond on count 1 and a $1,000 bond on count 2. Mr. Anderson's been here his whole entire life. He's 47 years old. He's working for a city and their utilities department for over 17 years now. He lives with his wife and kids. Basically, Mr. Anderson supports his family, Judge. My understanding is I believe he may have had only 1 contact as far as misdemeanor trespass back in 1994. He's a registered voter here in our community, and most important, Judge, my understanding is he's been having conversations with Mr. Detective Martinez of, I believe, the Fort Lauderdale Police Department. Detective Martinez contacted Mr. Anderson, advised him that there was a warrant. Mr. Anderson came and voluntarily surrendered himself at the main jail. He is not flight risk. He's looking forward to having his day in court. But Judge, we're going to be asking, based on his strong ties to community, not being a flight risk, that he turned himself in, Judge. We're going to be requesting a $5,000 on 1, $1,000 on 2.
All right, I find probable cause. Count 1, the bond will be $10,000. Count 2 will be $1,000. No victim contact until further order of the court.
Thanks.
All right, Mr. McLawrence, I believe you have a few. Good morning.
Michelle Williams. She's over at Paul Ryan facility.
Okay.
She's also the next case on the docket, Judge.
She's the next case on the docket. Thank
Morning,
you.
Michelle.
Good morning.
Good morning, Ms. Williams.
Good morning, Your Honor.
You're before the court for 2 misdemeanor capious matters and trespassing and resisting without violence. I do find probable cause. What does Ms. Williams wish to do?
Judge, she would like to resolve, and just for the court's edification, Ms. Williams, this would be her first offenses. The city had originally offered her the diversion program back when I originally represented her. So I'm asking the court to withhold and take judicial notice of the time served in consideration of that.
Okay. All right. All right, Ms. Williams, I will sentence you to withhold and take judicial notice of any time you've served. Is that how you wish to resolve your case?
Yes, Your Honor.
All right, please raise your right hand, ma'am. Is swear affirm to tell the truth?
Yes, Your Honor.
All right, you can put your hand down. Do you understand everything that's going on here today?
Yes.
And do you need more time to speak with your attorney?
Yes.
You need more time to speak with me, Michelle?
Well, I just wanted to clarify. So this will resolve it if I just pay the fine today?
Well, it will be resolved today, and then once you pay the fine, yes, everything will be closed out.
Okay.
All right.
That's it?
That's it?
Yes.
All
Your
right.
Honor.
Are you under the influence of drugs or alcohol?
No, Your Honor.
Is anyone forcing you to resolve your case?
No, Your Honor.
You understand you have the right to go to trial by taking a plea? You're giving up that right? Do you understand that? That you're giving up your right to go to trial by taking a plea today?
Yes.
All right. And do you understand that if you're not a U.S. citizen, that by taking a plea, it could subject you to deportation or immigration changes?
Yes, Your Honor.
All right. What plea do you wish to enter, Ms. Williams?
No contest.
All right. I accept your no contest plea. Find that it's freely and voluntarily given. Your sentence is a withhold adjudication. I'll take judicial notice of time served. And do you need time to pay your court costs?
I'll pay today, as soon as I can get to my credit card.
Judge, could we get 6 months, please?
All right.
Thank you, Judge.
I'll give you 6 months to pay your court costs. Good luck, ma'am.
Thank you. Thank you so much.
All right. Mr. McLaren, is that all you had?
There was one other person, Judge, but he bonded out.
Okay. All right. Thank you. Ismael Quiles. Mr. Quiles is on page 18. Is he represented by the Public Defender's Office? And have you had time to speak with him?
I have not, Judge.
All right, we'll recall when they're ready. Yeah, the prosecutor for the case is in the courtroom, so. All right.
Sheila?
Okay, then we'll go to Joanne Brown.
She's a medical loan, Your Honor.
Okay.
Your Honor, you're not sure if PC's ever been found?
If who?
What probable cause has ever been found?
Well,
If not, I would ask the court. I think it's been a little while now.
these paperwork are all confusing now.
Well, then,
There's a line drawn through the one with Judge Benson, but not where Judge DeLuca signed. It looks like he found probable cause. So, and then after that, people kept signing and crossing it out. So, in an abundance of caution, I will make a finding of probable cause today.
I have no objection to that, Judge.
And then I guess now we can make a notation that only bond needs to be set so that we don't go through this again. I just wanted to, I needed to clarify. Courtney Silver, is Miss Silver?
She's going to be a medical reset, Judge.
Okay, but Courtney Silver is the lady that we handled yesterday afternoon.
Yes, ma'am.
And these 2 counts were handled. And everyone will remember that was my concern and question yesterday. Is she going to be back on the docket? And she is.
And there she is.
So these were all handled yesterday.
I see that bonds were set by the court, I think $750
Yes.
on each count.
Perfect, so they were gonna make a call and
Okay.
relieve her from
So, all right. So I forgot to say that earlier. All right. Jacqueline Nebellini.
Paul Ron, Your Honor.
Okay. Ms. Nebellini, you're before the court for it's a capious matter, and the charge is trespassing. I do find probable cause. Do you know what you want to do today, ma'am?
I would like to resolve it today.
All right.
I've been in here for 5 days. I would like to get a time served.
Okay. Well, you were reset a few times for medical reset, so.
Yeah.
All right. I will sentence you to adjudication and time served. Is that what you want to do?
Yes, ma'am.
All right. Please raise your right hand. You swear or affirm to tell the truth?
Yes.
Okay. You can put your hand down.
Thanks.
Do you understand what's going on here today?
Yes, I do.
And do you need time to speak with your attorney?
No.
He was here yesterday, as a matter of fact.
Wow.
Okay.
Okay.
Are you under the influence of drugs or alcohol?
No.
Is anyone forcing you to resolve your case?
No.
Have you ever been treated for mental or emotional illness?
No.
And do you understand that you have a right to go to trial and that by taking a plea today, you are giving up that right?
Yes.
And do you understand that if you're not a U.S. citizen, that by taking a plea, it could subject you to deportation or immigration changes?
I'm a U.S. citizen.
All right. What plea do you wish to enter, Ms. Nebellini?
No contest.
All right. I accept your no contest plea. Find that it's freely and voluntarily given. I will sentence you to adjudication and time served, and I will give you 6 months to pay your court costs. Good luck.
Thank you.
All right.
And Judge, whenever the court's ready, we're ready to proceed on Mr. Keelis.
All right. So Mr. Keelis is on page 18.
Approaching, Judge.
All right. Mr. Keelis, Ismail Keelis, you're before the court today for one count of DUI causing death to any human. Count 2 is DUI causing death to any human. Count 3 is vehicular homicide. Count 4 is DUI with damage to property or person. Count 4. Count 5 is DUI with damage to property or person. Count 6 is reckless driving, and count 7 is reckless driving.
Morning, Judge Veronica Rivera, State's Traffic Homicide Unit.
Good morning, Mr. Rivera. All right. Unless I'm missing something, there's only one death that's recorded in this affidavit.
Correct, Judge. There's one death. There was also property damage to Mr. Brommer, who is the individual that was killed. There's also property damage to Mr. Poner, who is the individual that was driving the truck. Mr. Bronner was struck while he was a bicyclist.
No, I know. I'm addressing counts 1 and 2. That I'm not finding probable cause for one of them because there's only one death that was,
They're charged differently, Judge. One is for the blood alcohol level, and one is for impairment. I did bring the traffic homicide report, which goes further into the impairment that was found. If I could approach and show the court.
Sure.
Just not much more serious.
There's also a diagram attached and one photograph.
No, I want the answer to counts 1 or 2. Are there 2 DUI causing death, or what is it?
Judge, there's one death. One is with the signs of impairment that were observed, which was a slurred speech, the odor of alcohol beverage, bloodshot, glassy eyes, a witness stating that Mr. Quiles was incoherent, not understanding what was being said. And so that is an impairment charge. It is also charged as unlawful breath or alcohol level, given that his blood alcohol reading was 0.16, which is 2 times the legal limit. So it's two separate charges, even though there is one death.
Your Honor, if I may, it would be akin to someone getting charged with just a regular DUI with an enhanced breath, and then the second count of a DUI, either property damage or just a DUI. It's just under an alternative theory, Your Honor. Of course. See, here's the deal.
All right. Okay, well, hold on. Let me finish dealing with this, and then I'll do that. All right, okay. All right, on Mr. Quiles, okay, I do find probable cause as to all counts, and I will hear from the parties as to bond.
Thank you, Judge. The state is seeking $100,000 fully collateralized on counts 1, 2, and 3. There's obviously the standard bonds on the remaining DUI and reckless driving counts. The state is also seeking no driving, no drugs or alcohol with random testing, level 1 pretrial with GPS, and to surrender a passport and to not apply for one during this case. As I stated, there is a witness on scene, Mr. Villa. Mr. Villa did observe additional signs of impairment. He actually was driving in front of the defendant, and he observed the cyclist moved out of the way, and immediately following that, saw the defendant crash into the cyclist, Mr. Brommer, and continue his impact into the truck, which caused the truck to flip. And if the court looks at the photograph that I provided could see the severe damage sustained to the truck. So Mr. Quiles was driving 61 miles per hour at the time of impact. This is Davie Road. This was a 35 mile per hour area. The impact to Mr. Brommer at that speed flew his body over 100 feet away from the initial impact area. The state also has further concerns because Mr. Villa did observe immediately after the crash Mr. Quiles trying to restart his vehicle. He had concerns on scene that the defendant was trying to flee the area, and that witness actually grabbed the keys from the ignition and ensured that the defendant remained on scene, where the officers were able to obtain his blood, and as I said, it came back as twice the legal limit. So that is what the state is seeking as far as bond.
And did you say 100,000 on each count? Is that what you...
I did, and I do want to bring to the court's attention one thing that I forgot. Actually, after this case, the defendant did pick up a burglary dwelling in October. This case happened in September, so he is actually on pretrial release on that second-degree felony case that's open.
Okay.
Judge, that is correct. And speaking of Mr. Quiles, he did advise me of that. I believe he's actually, from what he told me, on a level 2, in which he's been on it for about 6 months with no sort of violations. He's actually, I believe, being represented by regional counsel on that case. Judge, in speaking to him as far as the bond, monetary bond, which the state is suggesting as far as $300,000, that's just simply something Mr. Quiles cannot afford. He's been here his whole entire life. He was born here. He's 33 years old. He works in landscaping, so there's no way he can possibly come up with that monetary bond. Now, he lives with his parents. His mom works for the post office. He's been living at that same address now for about 22 years. Judge, as far as what the state has suggested as far as surrender a passport, and speaking of Mr. Quiles, he's a U.S. citizen. He's not in possession of a U.S. passport or U.S. passport card. He's never applied for a U.S. passport or U.S. passport card. I'm asking the court not to impose that condition because there's no passport that he can possibly surrender. So as to that particular aspect of the state's request, I'm prepared to swear in Mr. Quiles under oath, and he will attest to what I've just apprised the court as far as that. He has no passport. Judge, other than that, I'd ask you to impose a reasonable bond on Mr. Quiles' behalf.
Counselor, have you made a determination that he has a passport? Or is
I have not. I would then just ask that he does not apply for one during this case.
Okay.
No problem.
Okay. I do find probable cause. There are great concerns for the community in regards to these allegations. And so as to count 1, I will impose a bond of $100,000. On count 2, I'll do $2,500. Count 3, I'll do $50,000. And then counts 4, 5, 6, and 7, the standard bonds that are in place will remain. And Mr. Quiles is, you'll give me an order that he shall not apply for a passport. All right, we've covered all the conditions.
Is this court putting the defendant on pretrial release?
Yes, that's why I was asked if I missed something.
Oh, I had asked for level 1 judge with no driving, no drugs or alcohol, and random testing.
Level 1 GPS, no driving. Drug and alcohol testing is being ordered.
Thank you, Judge. I will write a short order. Are the bond amounts fully collateralized?
Yes.
Thank you, I will write that order.
All right, Mr. Keeler, good luck. What was this now? Oh, that was the most recent one that was presented.
Should be the next one. Where's she gonna go?
But is it correct that that possession of cocaine is one of the charges? I don't understand why.
Is that on Joanne Brown?
Yes.
She was an ad charge. She was booked in on the 12th, and then she got ad charge on the 13th, and then she kept being medical reset.
So the possession of cocaine is an ad charge?
It was an ad charge. So she was never magistrated.
You're staying in line the next two are both Mr. Sheet.
Okay. All right, Mr. Sheikh, good morning.
Good morning, Judge. I have a few, but I think a couple of them are medical resets. And I know we've done those.
All right, on page 9, Lisa Finelli. That was a reset from.
Yes, Your Honor, she's North Broward.
Oh.
Come on, Lisa. And Miss Robin Simmons is next.
Okay, thank you.
Lisa, you're first.
Ms. Finelli, you're before the court today for 2 counts of a municipal ordinance violation. And I do find probable cause. Ms. Finelli, what do you wish to do today?
Judge, the offer from the city would be time served.
Okay.
But I'm not
Go
sure.
home?
Lisa, how are you feeling today?
Yes.
How are you feeling, Lisa?
I want to go home.
You want to go home, you sure? Wouldn't want to stay
Yeah.
and maybe see the doctor?
No, I want to go home.
All right, Judge, the offer would be time served. However, I do have concern for her health. I know that the jail isn't a medical facility. It's supposed to be holding people, but looking at her condition and knowing that she was a medical reset, it might be better for Ms. Finelli if she was sent to the division and see a doctor.
That's what I'm inclined to do. I am not comfortable that Ms. Finelli should take a plea today. I wouldn't be comfortable doing that. So
What do you mean?
I am going to leave the bond in place.
You're not going to send me home?
You're going to see the division judge.
Come on, I'm fine.
All right, ma'am. We're going to go to Ms. Simmons now.
So what does that mean?
You're going to go back inside cell 3, and we're going to get you back to the medical unit.
So I'm not going home?
That's what she said.
Not today, Lisa.
Can I ask why?
You'll probably be in court again on Monday. I'll speak to the judge and have you brought in on Monday.
Why though?
All right.
I'm fine.
All right, Ms. Simmons. We need to do Ms. Simmons now.
All right, you're done. Come on. That's her final decision.
But what's the decision?
That's her final decision. Step out so the next one can come in.
Good morning, Your Honor.
How you doing today,
I
Robin?
don't know what no.
I'm fine. How are you?
Regular
Good,
division
good.
she's got to go.
The city of Pompano is going to give you a time-served plea. Would you like to accept that?
Yes, I would, sir.
Okay.
All right. Ms. Simmons has been before me recently, I think.
Correct, Your Honor.
When was the last time Ms. Simmons was here?
I guess 2 weeks ago, if I'm not mistaken. Is that
All right,
correct,
well, I
Robin?
wasn't here last week, so it would have been before.
I think it was 2 weeks. About 2 weeks ago, were you here, Robin?
Yes, for the same thing.
Great concerns about All right, Ms. Simmons, I'm going to tell you, the city has offered adjudication and time served for you to resolve your case. But, you know, in your own words, I was arrested for the same thing. So what can we do, or what can your attorney do to help you not be in the situation again? Because 2 weeks ago you were here. Today you're here. You do sound, to be of sound mind.
It's a situation that I feel that I have to do on my own, okay? I might be seeking some counseling and get into a facility.
Okay.
But I know that what I've done is wrong. I know. Okay? I don't want to be back here again.
Okay.
So I'm going to check out Bark on my own when I get out of here, or Henderson or something, and try and make this thing not happen again.
Okay, I'm not scolding you or anything. I'm just trying to encourage you to do something different.
Yes, I understand, and you know what? You have every right to say it. So.
All right.
Yes.
Because I don't want to see you in this place too often, and I'm sure you don't want to be here either. So.
I don't want my life like this.
Right. All right. All right. So let's go to the plea. Please raise your right hand. Do you swear or affirm to tell the truth?
Yes.
Okay, you can put your hand down. And Ms. Simmons, do you understand everything that's going on here today?
Yes, I do, Your Honor.
Is anyone forcing you to resolve your case?
No, ma'am.
Are you under the influence of drugs or alcohol?
No, ma'am.
And do you understand that you have the right to go to trial, but by taking a plea today, you are giving up that right?
Yes, ma'am.
And do you understand that if you're not a U.S. citizen, that by taking a plea could subject you to deportation or immigration changes?
Yes, ma'am.
All right. What plea do you wish to enter?
No contest.
All right. I accept your no contest plea. Find that it's freely and voluntarily given. Your sentence is adjudication and time served, and I'll give you 6 months to pay your court costs.
Let me ask you, you asked me a question earlier if there's anything that my lawyer could do to help me. What is it that I could do from outside, and where exactly could he direct me to go for a facility that could give me help?
Well, maybe you want to give him a call so that you both can talk off record. Okay?
Okay.
You're thinking right by going to Bark. Go check out Bark if you can. Okay? Because otherwise you're going to be court ordered there soon if you continue to show up. So,
all right.
Check out Bark.
Thank you. Thank you.
All right. You're welcome.
Judge, if I may, real quick. The deputies are asking me, one of the gentlemen on the docket is being called to a courtroom, so I don't even know if he should be here. His name is Jarius Merritt on page 3. It seems like he has violation of probation.
What's the last name?
Merritt, Merritt. He was on page 3 of the docket on the domestic part of it. He's on violation for a domestic situation, but he's being called right now to go to court.
I don't.
Yeah, Your Honor, it's a VOP from Judge McHugh and a VOP from Judge Levy. I imagine he's going to be brought to Judge Levy. I don't even know that he needed to be brought through. Sheila?
Okay, so it should be deleted from here, from magistrate.
Sheila with 2 VOP warrants?
Do we even have his paperwork?
I mean, I had his paperwork, but I passed it through because it was on 2 VOP warrants.
Okay. Yeah, I don't think they even gave me his paperwork. So
okay, so
he should go to his division. Yes. Okay? All right, let's continue. Mr. Shade, on page 11, Corey Butts. Yes. Is this Mr. Butts?
Corey?
Yes.
Yes.
All right, Mr. Butts, you're before the court for one count of a misdemeanor KPS for trespassing. I do find probable cause. What does Mr. Butts wish to do?
Judge, the city of Hollywood would offer him time served on this.
Mr. Butts, you want to resolve your case with adjudication and time served? Turn the microphone on.
The button.
Yes, ma'am, I do.
All right, please raise your right hand. Is sir affirmed to tell the truth?
Yes, ma'am.
Okay, you can put your hand down. Mr. Butts, do you understand everything that's going on here today?
Yes, I do.
Is anyone forcing you to resolve your case?
No.
Do you need more time to speak with your attorney?
No, ma'am.
Are you under the influence of drugs or alcohol?
No, I'm not.
And do you understand that you have a right to go to trial? By taking a plea today, you are giving up that right.
Yes, ma'am.
Have you ever been treated for mental or emotional illness?
No, ma'am.
And do you understand that if you're not a U.S. citizen, that by taking a plea, it could subject you to deportation or immigration changes?
Yes, I understand.
What plea do you wish to enter, Mr. Butts?
No contest.
All right, I accept your no contest plea. Find that it's freely and voluntarily given. Your sentence is adjudication and time served, and I'll give you 6 months to pay your court costs, sir. Good luck.
Okay, thanks.
And then Herbie Crussell on page 15.
Hello, Your Honor.
Good morning, Mr. Crussell. You're also another person who's repeating.
This is a warrant for an old one. I haven't been doing what you told me, what you stated you didn't want me to do.
Uh-huh.
I'm in a program.
Okay.
No, this is for an old one. I haven't been doing what you told me not to do.
All right. Well, this one is from February 21, 2019.
Yes, ma'am.
All right.
I haven't been doing it.
Okay. So you're at a stable place now?
Yes, I am. Yes, I am.
And you're working towards making things better?
Yes, I am.
All right. So so I won't see you again for any new arrest, right?
No, you haven't. No, you haven't.
I haven't for any new one, but I'm saying in the future. I'm not going to see you again.
Hopefully not, Your Honor.
All right, Mr. Crusoe. Oh, honesty is best. All right. The offer is adjudication and time served. Do you wish to resolve your case with that?
Yes, I do, ma'am.
All right, please raise your right hand. Is sir affirmed to tell the truth?
Yes, I do.
All right, put your hand down. Mr. Crusoe, you understand everything that's going on here today?
Yes, I do, ma'am.
And do you need more time to speak with your attorney?
No, ma'am.
Are you under the influence of drugs or alcohol?
No, ma'am.
And you understand you have the right to go to trial, but by taking a plea today, you're giving up that right.
I understand, ma'am.
And you understand that if you're not a U.S. citizen, by taking a plea, it could subject you to deportation or immigration changes.
I understand.
What plea do you wish to enter, Mr. Crusoe?
No contest, ma'am.
All right, I accept your no contest plea. Find that it's freely and voluntarily given. Your sentence is adjudication and time served. I'll give you 6 months to pay your court costs. And one more time, I just want to encourage you to keep doing what you're doing to stay out of coming in front of me like this, okay?
I'm trying, Your Honor. I'm trying.
All right, good luck.
Okay.
All right, Mr. Shade. Okay, let's see. Shaquita McCrae.
Your Honor, that's North Broward. She has a medical reset, please.
All right.
I think, yeah, she did the orders, I believe.
And Jabbar Tolbert. You have Jabbar Tolbert.
Brief recall, Judge. I believe he's in back.
Okay. Lawrence Jones.
Mr. Jones, come on up, please. He's approaching, Judge. He's here at Maine.
Mr. Jones is before the court today for one count of trespassing. And the court does find probable cause.
Judge, in speaking to Jones earlier today, he wishes to resolve this matter.
Okay. Does the state have an offer for Mr. Jones?
Yes, Judge. The adjudication time served.
All right.
He wishes to accept the state's offer, Judge.
All right, Mr. Jones, please raise your right hand. Is swear or affirm to tell the truth, sir?
Yes.
Okay, you can put your hand down. Mr. Jones, you understand everything that's going on here today?
Yes, I do.
And is anyone forcing you to resolve your case?
Oh, ma'am.
And do you need more time to speak with your attorney?
No.
Are you under the influence of drugs or alcohol?
No.
Do you understand you have a right to go to trial? By taking a plea today, you are giving up that right.
Oh, what's that, sir?
Yes.
And have you ever been treated for a mental or emotional illness?
No.
And do you understand that if you're not a U.S. citizen, that by taking a plea could subject you to immigration or deportation changes?
Yes.
What plea do you wish to enter, Mr. Jones?
No contest.
All right, I accept your no contest plea. Find that it's freely and voluntarily given. Your sentence is adjudication and time served. And no return to 3460 Northwest 9th Avenue in Oakland Park, Florida. Okay? Do you understand that, sir? I'll give you 6 months to pay your court costs.
All right.
Good luck,
right,
sir.
Take care.
Mr. Judge, Mr. Tolbert is here.
Okay.
I ain't got no warrant. They arrest me to say I ain't got no warrant.
Okay.
I'm supposed to be out on same day.
Mr. Tolbert is before the court for one count of trespass. And I do find probable cause. What do we wish to do?
Judge, we're going to be asking for the court to consider releasing Mr. Tolbert ROR.
Yeah.
Your Honor, my concern is showing that Mr. Tolbert has 3 pending cases in front of Judge McHugh, all for violation of a domestic violence injunction.
And do we have, is there any mental health concerns?
It looks like there are issues. I would ask that this go
right.
to Judge Lerner-Wren.
I'd be more inclined, I find probable cause, I'll be more inclined to sign an order to send Mr. Tolbert to Judge Lerner-Wren's division. And I'll leave the bond in place. I will try and get him on the docket as soon as possible.
I'll notify her judicial assistant.
All right, so I'll sign that order to transfer. The bond is $25. Good luck, sir. Danielle Makira. Okay.
Your Honor, I would just request, since he is present in the courtroom, if the court should order a no victim contact, please.
Mr. Makira, you're before the court for one count of battery. I do find probable cause, and I've also been told that your bond has been posted. Sir, I'm also imposing a no victim contact until further order of the court.
Yeah, okay. Good luck, sir.
All right. I know on page 24, the bondsman is here on Marcel Davis. When you let me know when you're there, Mr. Romero.
I'm ready to proceed, Judge.
Oh, okay. All right, so then we can call Mr. Marcel Davis on
Mr.
page 24. Okay. Um, all right. Mr. Davis is before the court for 3 counts of sexual battery on a victim 18 years or older. The court does find probable cause, and I will hear from the parties as to bond.
Thank you, Your Honor. Based on these allegations, I do have a concern for the safety of the alleged victim and the public. I would note the strength of the case, specifically referring to audio recordings taken of one of the alleged incidents that is referred to in the arrest warrant affidavit. Your Honor, I'm going to be requesting bonds in the following amounts: $50,000 on each count, pretrial release with a GPS monitor, and no victim contact with the alleged victim, whose initials are CF.
Okay. Mr. Bondsman, you're here.
Yes, ma'am. I'm here on behalf of the wife who contacted me, and she thought it was just an assault battery case until we found out from speaking to Brian the seriousness of the case. I did speak to her. They have limited funds, almost no funds at all. They just started a company 2 years ago. So I did make her aware of the situation, which she was shocked and surprised. So, but funds are very limited for the family.
Okay.
That's what I was going to go ahead and expand on. My understanding, judges, he did open up a company with his wife, and right now they're operating at a loss. Now they do own their home, but which they purchased approximately 3 years ago, so there's not much equity in the home, and his mortgage is approximately $1,700 per month. He advised me his first arrest. He's a registered voter here in Broward County, but right now he's able to afford $150,000, which the state has suggested. What I'm going to be asking the court to consider is a $20,000 bond on each count.
Okay. All right, I find probable cause, and the nature of these charges are pretty serious. The allegations are serious. And so I find that $50,000 on each count is a reasonable release condition. If Mr. Davis posts these bonds, he's also going to be on pretrial supervision with a GPS. And no victim contact.
Thank you, y'all.
Thank you, James.
Yes, ma'am.
CF.
CF is in front?
Yes.
Thank you.
Jamari Bullard.
I can forward you a copy.
Oh, Judge, I've been advised he bonded.
Okay. Barry Williams. Where? On count which one? Oh, okay. All right, Mr. Williams, you're before the court for one count of petty theft, second offense, and count two is a misdemeanor capias, which is also on a petty theft charge.
Mr. Williams was currently being supervised by pretrial services. He was placed on pretrial GPS on the 13th of this month in case number 19-3321 CF10A, one count of petty theft and one count of possession of alprazolam. Based on this court's finding of probable cause, we're going to ask that his pretrial status be revoked at this time.
Well, what happened? Where did Mr. Williams go?
Judge, come on back, Mr. Williams.
All right, Mr. Williams.
We're going to be requesting just a medical screening.
Okay. As to case number 19-003321 CF10A, Mr. Williams was placed on pretrial supervision on March 13th with GPS. I am going to revoke that pretrial release. Count one will be a bond of $250, and count two will be $1,000. And I will sign the order that's requested. As to the new charges, I do find probable cause, and I will leave the standard bonds in place, $100 and $500. That was a capias from Judge Schiff from March 12th. So, all right. Javier Ventura.
Judge, he bonded.
Okay. Brian Kirama.
Mr. Kirama is here, present, Judge.
Mr. Kirama is before the court for one count of touch or strike battery, and the court does find probable cause. I will hear from the parties as to bond.
Yes, Your Honor. The state would be requesting a bond increase to $5,000. Frankly, I'm very concerned about the level of violence alleged in this probable cause affidavit. Mr. Kirama, for lack of a better term, terrorized this victim, first physically attacking her, and then after that, literally getting on top of the hood of her vehicle and punching her vehicle windows. This was witnessed by independent witnesses, Your Honor. The victim was too scared to come out of her vehicle after she retreated after being physically attacked. I would note for the court's consideration that Mr. Kirama, according to the Florida Department of Law Enforcement, is a registered gang member. He has gone to state prison, 2015, tampering with evidence, 2013, possession of firearm, ammunition, or weapons by a convicted felon or adjudicated delinquent. He violated probation and was sentenced to 46.5 months in Florida State Prison. He has 4 total felony convictions. One moment, Judge. Nothing further at this time, Judge.
Okay.
Judge, in speaking to Mr. Kirama right now, he's not going to be able to afford the bond increase. We're going to be asking the court to leave the standard bond in place. Mr. Kirama is working. He works for Papa John's. He's supporting his girlfriend and him. He's going to be a father. His girlfriend is pregnant. They rent an apartment in Coral Springs. Now he does not believe his girlfriend has any funds to help him out. He gave me the phone number of his mother. That's who I'm going to be reaching out to after court to post his monetary bond. But he's not even sure as far as if she's going to be able to afford the $1,000. So I'm going to be asking the court to just leave the bond in place.
All right, I do find probable cause. There is great concern for the community based on the allegations in this affidavit. I am going to impose a bond of $2,500, and that will also be with a pretrial supervision with the GPS. Okay, sir. Christopher Rapp.
Judge, I've been advised he went to regular court.
Okay. So 37, Mr. Rapp. Trayvon Sutton.
Mr. Sutton is here at Maine, approaching, Judge.
His sister is also here, Judge.
Okay. All right, Mr. Sutton, you're before the court for it's an ad charge of grand theft auto. Now, the court does find probable cause, and I will hear from the parties.
Your Honor, he's being held, count one, $2,500 bond plus a GPS. You may recall he appeared before you yesterday in the strong-arm robbery. That was the case involving the owner of the vehicle advised law enforcement that he had the vehicle at the time of the robbery. The victim could not make an identification, Your Honor, based on the circumstantial evidence. ROR'd him to pretrial GPS on that count.
Yes, Judge, and I would argue that the evidence in this case is not a lot stronger. The only thing at least connecting Mr. Sutton to this grand theft auto is that his fingerprint is found on the rearview mirror 3 days after the car is stolen. I think it's a very big stretch of the imagination to say that because his fingerprint is in the car 3 days later that he's the one who stole it, or that he should have known that it was stolen. There's absolutely no other evidence in this case. In light of the fact that he's already on pretrial release on the other counts, I'd ask the court to consider an ROR to pretrial release on this case, in light of the fact that the evidence here is far from compelling.
Your Honor, one, and the court found probable cause. Accepting Mr. Reedy's arguments, it would certainly seem like Mr. Sutton is having an awful run of bad luck lately. We got one person saying, yeah, he had my vehicle, the same vehicle that a person that committed a strong-arm robbery left the scene in, the same vehicle where the victim's stolen property is found in. Now, his fingerprints happen to be found on the interior of a stolen vehicle on the interior rearview mirror. It just seems to be an awful, lightning seems to be striking in the same place randomly at the same, in multiple occasions.
With all due respect, that is not at all what we had yesterday. I don't want to go through all the arguments I made at that time, but we do not have someone who can identify Mr. Sutton as being in possession of that vehicle on the date of the robbery, because that person's name was never taken down by the officer in his probable cause affidavit. We have absolutely no idea who that person is. All we know is that the victim in the case, when presented with a photograph of Mr. Sutton, was unable to make an identification of him. And here we have a situation where the only evidence linking him to the grand theft of the car is a fingerprint found 3 days after the car is stolen, which is not the same as having stolen the car. So, again, Judge, I respectfully disagreed with the court's finding of probable cause yesterday. I don't think that this case is any stronger than that one. And again, I'd ask the court to consider releasing Mr. Sutton, ROR, to pretrial release. He's already being supervised by them. He has family members here to support him, so obviously he has ties to the community.
Did you want to say something?
Yes, I was going to ask the same, because I can afford the firstborn with the pretrial. He's going to be living with me.
Okay.
So that's basically what I was asking.
All right. Well, the attorneys know that today's not the trial, so you'll have time to prepare. How are you related to Mr. Sutton?
That's my brother. brother.
Okay,
Say
so,
mom and dad.
so you'll have, his attorneys will have time to prepare, their defense and whatever other arguments they wish, to present. But for today, I do find probable cause, and I am going to leave the bond of $1,000 in place on this count. All right, good luck.
Judge, if I may, and speaking Mr. Sutton, I know his sister and his family have been trying hard to come up with a monetary bond that's just, he's currently $2,500. I believe they just today finally were able to get those funds. Besides the mitigating circumstances, my colleague argued yesterday, I believe the court also took into account that fact that he was still here and he financially couldn't even afford to post a $2,500 bond. And I believe that's why I asked the court to also take that into consideration in releasing him on, I believe, level 2 pretrial release yesterday. Judge, at this time, I'm still making that request as far as have Mr. Sutton be released on level 2 pretrial release, because I don't think, like the sisters here, I don't think she can afford an additional $100 with the bondsman, Judge.
And additionally, I'm asking the court to consider, in addition to these 3 charges, he already has a pending aggravated battery against a pregnant victim, and he's been to prison from 2015 grand theft auto.
I'm going to deny the request for the pretrial. It's $1,000 on this count. You wanted to say something else, ma'am?
Yeah, because she dropped the charge. She took a class and all.
That's not before me today, so, and what was before me yesterday, that's something different as well. Today, this is another charge with another set of facts that I'm looking at, okay? All right, good luck. Alfred Gillis.
Judge, I've been advised he went to regular court.
Okay, so we have to reset Mr. Gillis. All right, Trayvon Washington.
Mr. Washington, come on up.
Mr. Washington, you're before the court with 1 count of robbery with a weapon, and count 2 is aggravated assault with a deadly weapon without intent to kill.
When you get the cases, they're in order. No, that's not good.
The court does find probable cause. I'll hear arguments as to bond.
Yes, Your Honor. Your Honor, the state is going to be requesting a $25,000 bond and a GPS monitor on this first-degree felony involving violence. I'm showing in 2000 and, I'm sorry, 25,000 on 1, 10,000 on 2. I would note in 2012, Mr. Washington was convicted of burglary of a dwelling, resisting without violence. He violated probation. He was sentenced to 40 months in Florida State Prison. He was released in 2016. One moment. In August 2016, so I would note also that he could potentially be qualified as a prison releasee reoffender in this case, so that could enhance the consequences if convicted.
Judge, in speaking with Mr. Washington, unfortunately, he's homeless, Judge. He's financially indigent. There's no one that's going to be able to afford to post a monetary bond for him. So, Judge, I'm going to ask you to take that into consideration in determining reasonable release conditions for Mr. Washington. And I'm also going to ask you to for a medical screening, Judge.
All right, I will sign the order for medical screening. I have found probable cause. I will impose a bond on count 1. at $10,000. And on count 2, count 2 will do $5,000. And no contact with the victim in this case. And no return to this location. The store is located at 460 West Broward Boulevard.
It looks like it's a 7-Eleven.
At the 7-Eleven.
Thank you, Judge. Patrice, someone's here for you.
Okay, sir, good luck.
She might be taking somebody out of turn. Hang on for a minute.
Yes, on page 23, Gregory Papile? Papile?
He's here present, Judge. Mr. Papila?
Have you had an opportunity to speak with him? Okay, so
No, I haven't.
I'll call it when you're ready. There's someone who signed in the courtroom. That's the only reason why I was calling it. His girlfriend is here.
Step back up.
All right, the attorneys need to talk to him, ma'am, so. All right, so Demetrius Mesadu.
That's North Broward, Your Honor.
Thank you.
How you doing, ma'am?
Good morning, sir, I'm well.
Morning to you.
You're before the court today for one count of possession of a weapon or ammo by a delinquent or adult felon, and I do find probable cause. Does anyone wish to be heard as to bond?
One moment, Judge.
Listen to them. Listen to them.
Yes, Judge. I'm going to be requesting a $5,000 bond in a GPS. Without going into specifics, I can tell you Mr. Mesadu has a lengthy juvenile history and multiple priors involving violence. At least one is referenced to in the probable cause affidavit.
In speaking with Mr. Mesadu, Your Honor, he indicated to me that he has been a resident of South Florida for all of his life. He believes his mom might be able to come up with some money to bond him out, but I'm going to have to get a hold of his grandmother to get a hold of his mother. I'd ask the court to set as low a monetary bond as possible in this case, 'cause I don't really think that there's a lot of money that the family has to post a monetary bond.
Okay, he's raising his hand, so.
Mr. Mesadu, I'd advise you don't say anything about the facts of the case.
No, I'm not, sir.
Okay.
I'm talking about the bond.
Okay.
I got all my aunties them and like my cousins them. They older girls, and then when I called them yesterday, they said they'll pay for the bond.
Okay, and how much of a bond? I know you didn't tell me that earlier, but how much of a bond do you think they could make?
What, 500?
What were you asking for, Mr. Linder?
5,000.
How much that is?
I'd ask for 2,500, Judge.
How much that is?
250.
All right.
Oh, this is a social media.
Yes, Your Honor.
All right, I will impose a bond of $2,500, but I'm also going to have Mr. Mesadu on, is he on pretrial supervision?
Not that I see.
And we'll also add standard pretrial supervision.
And Your Honor, and it's.
He's on, he's on probation on something else? All right, so I won't add pretrial. He's already being supervised. I'll leave it at 2,500.
And Your Honor, it might be a bit redundant, but I would ask for a release condition, no firearms.
And Mr. Mezadou, until
Yes,
further
ma'am.
order of the court, no firearms or weapons.
Yes, ma'am.
Okay.
Yes, ma'am.
All right, take care.
Yes, ma'am. Thank
Good
you,
luck.
Honor.
I'll call your grandmother.
Yes, ma'am. Thank you, sir.
All right, Judge Powell, that completes North Broward. Glad to have you back.
You're welcome. Thank you.
I'll see you at 1.
All right.
Bye.
Francisco Rivas Marquez.
$150 and whatever collateral they have up to $25.
Judge, he's here present. He declined the service as public defender.
Okay, Mr. Marquez, you're before the court today for one count of grand theft. And I do find probable cause. And so, Mr. Marquez, do you have a private attorney?
I'm planning to hire one.
Okay, all right. So at this time, I have to set a bond, so I will hear from you if you have anything that you want to say in regards to me setting your release conditions.
In what? I couldn't hear well.
I found probable cause, and so now we need to talk about your release conditions. So I need to hear from you, since you have declined the services of the public defender. Is there anything you wish to tell me in determining the release conditions?
Yes, well, I came here yesterday to the court building in order...
No. Do not, I'm not asking you about the facts of the case. I'm asking you about setting a bond. So you need to tell me whatever it is that you want to tell me about setting your bond.
Oh, well, I'm going to leave it up to you, Honorable Judge.
Okay. I appreciate that. Mr. Linder, do you have anything that you wish to say? Any priors?
I was just going to advise court. I don't see any criminal history, Judge.
Oh, okay. All right. All right. Mr. Marquez, I will release you on your own recognizance, and what that means is that you will be out without having to post a bond, but you need to pay attention to the mail so that you'll know when or if the state has filed the charges, and if they have, when you have to return to court.
Perfect. Thank you, Your Honor.
Okay, you're welcome. Good luck.
Thank you.
And whenever you're ready with Mr. Papile, you can let me know.
Oh, Judge, I think I am ready on Mr. Papila.
Okay.
I'll tell you right now. Yes, I am.
Page 23.
Mr. Papila, come on up, please. I'm ready to do it.
All right, Mr. Papile, you're before the court for one count of possession of THC, 2 is possession of cannabis 20 grams or less, and 3 is a municipal ordinance violation. I do find probable cause as to all 3 counts, and I will hear from your attorney in regards to bond, and I believe your girlfriend, ma'am, what's your name?
Veronica.
Veronica is also in the courtroom.
Judge, in speaking Mr. Papile, considering the charges are non-violent, Judge, we're going to be asking the court to consider releasing Mr. Papila ROR. My understanding is, from what he informed me, I believe last time he had contact with the criminal justice system was maybe well over 20 years ago. Based on these new charges, I'm going to be asking if the court would consider an ROR.
Say, okay, all right. All right, I will grant the ROR on these charges. And Mr. Papile, like the other gentleman before you, you need to pay attention to the mail to see if the state does file the charges, and if they do, when you have to come back to court. Okay? All right, good luck, sir.
Good luck, sir.
Thank you.
You're welcome. Jameer Forbes.
Mr. Forbes, come on up, please.
All right, Mr. Forbes, you're before the court for one count of resisting officer without, count one is resisting officer without violence, count two is resisting officer without violence, counts 3 and 4 are felony violation of probation, and also 5, 6, and 7 are also violation of probations. Counts 3 to 7 are no bond holds, and it looks like you'll be in court tomorrow and the day after on these matters. I do find probable cause, and the bonds on counts 1 and 2 are $100 each. Good luck, sir. All right, Robert Terwilliger.
He's approaching, Judge, if you may. Come on up, sir.
Sir, you're before the court for one count of possession of clonazepam. And I do find probable cause.
Judge, I'm going to be asking the court to consider an ROR Mr. Terwillinger's behalf. My understanding is he has a valid prescription. He tried to show that to the officers. Unfortunately, from what he informed me, where it was raining so bad that the prescription was smudged and the officers couldn't read it. But we're asking for an ROR. If not, Mr. Terwillinger did give me a phone number of his friend who I intend on reaching out to after court.
See, once again, this is curious because it says here that the label was removed. Had nothing to do with the rain or smudging. And I don't know if rain could even smudge that kind of type on a prescription bottle. I would note he's got 2 priors, possession of cocaine, 2012, cannabis, 2012. I was not going to be opposed to a pretrial, Your Honor.
Judge, he's saying
as long as I can take it to trial after pretrial, correct?
Yes, sir.
Then yes, I'll take pretrial.
Okay. All right. I will release you to pretrial supervision. And that's going to include random drug and alcohol testing.
Now I have a question for you. If I have Walgreens call in a new prescription and I bring it into you,
what you need to do is to talk to your attorney about whatever defense you think you have. Okay?
All right.
All right.
Thank you.
Charles Woods.
Mr. Woods is here present, Judge. Come on up, Mr. Woods.
Mr. Woods, you're before the court today for one count of grand theft, and I do find probable cause.
Judge, we're going to be requesting that the court consider releasing Mr. Woods on pretrial release. I'll see if the state has an objection before I proceed.
I don't have an objection to that.
Okay. All right, Mr. Woods, you'll be on pretrial release supervision. You need to follow the instructions being given to you and report to pretrial as soon as you're released.
Good luck, sir. You're being released. There's the location of pretrial.
James Dixon.
He's approaching, Judge, here at me.
Mr. Dixon, you're before the court for one count of grand theft auto and count 2 is resisting officer without violence. The court does find probable cause as to both counts.
Judge, I'm going to be requesting the court consider releasing Mr. Dixon ROR. My understanding is being Mr. Dixon, he has a clean record. I believe he may have been arrested one time on a trespass. I believe, from what he told me, I believe he may have successfully completed a diversion program and the case was dropped. He's 18 years old. He's working at a car wash, Judge. He doesn't think that a job's available to him any longer, but he goes to school. He goes to Piper High School where he's a junior. So, Judge, if the state can verify his lack of a criminal record, I'm going to be asking the court to consider an ROR on his behalf.
I don't see a history. That being said, I would be opposed to an outright ROR. My concern is he's willing, according to this, he's willing to go to the lengths of actually jumping out of a moving vehicle to avoid apprehension, then trying to gain entry into an apartment. Going by the address listed here, it doesn't appear he resides at that location. So I think some type of supervision, either a monetary bond or pretrial, would be appropriate.
To find probable cause, I am
Judge,
yes.
In that case, I'm sorry, I didn't mean to interrupt the court. I just spoke with Mr. Dixon. If the court's not inclined to an ROR, he did give me the phone number of his father, who he resides with, and I intend on calling him after court to post his monetary bond. So we're going to ask the court to consider an ROR or to leave the standard bond in place.
Okay, I'll leave the standard bond in place.
Thank you, Judge.
Marcos Torres.
Judge, medical reset for Mr. Torres.
Okay. Ricardo Rodrigo.
Mr. Rodrigo, come on up, please.
All right, Mr. Rodrigo is before the court today for one count of premeditated murder. Counts 2, 3, and 4 are felony violation of probation. As to the violation of probation matters, he will be before his division judge tomorrow, 3/21. I do find probable cause, and I will hear from the parties as to bond.
Your Honor, the state would be seeking a no bond hold on the top count of murder upon a finding of proof evident or presumption great for first appearance purposes only. At this time, the state would be relying upon the arrest warrant and arrest warrant affidavit prepared by Detective Elijah Thomas of the Fort Lauderdale Police Department that was signed by Judge Dennis Bailey.
In light of the fact that Mr. Rodrigo has other current pending no bond holds, we'll defer any argument regarding proof evident presumption great until such time as Mr. Rodrigo can appear in front of his division judge. However, at this time, we would be invoking Mr. Rodriguez's Fifth Amendment right to remain silent. We'd be advising the state and any and all law enforcement officers that they are not to make any attempt to contact Mr. Rodrigo to speak with him about this or any other matter without first contacting his attorney. And Mr. Rodrigo, I'm advising you, sir, do not speak to anyone about this case other than your attorney. Don't speak to anyone in the jail. Don't speak to anyone on the phone. They are recording your phone conversations and they are listening. So do not discuss this case with anyone other than your lawyer. Do you understand, sir?
Do you understand? Yes.
Okay.
Okay. I will make a preliminary finding of proof evident presumption great, and Mr. Rodrigo will be held no bond until further order of the court on count 1 as well. Okay, Thomas Spencer.
He's here, approaching, Judge.
Mr. Spencer is before the court for failing to report or his residence or name change, and I do find probable cause. I don't know, is there anything else other than this charge that he's on?
No, I believe it's just this charge on the arrest warrant, Your Honor.
Okay.
That being said, Your Honor, I'm going to be requesting a $7,500 bond, pretrial release with a GPS monitor. I think the GPS monitor is reasonable and necessary to so that law enforcement of the state can be aware of where Mr. Spencer is, since he, based on the nature of the offense. I would also note that he's already been convicted for this offense. In 2017, failing to report or register, he was sentenced to 487 days in county jail. Frankly, Your Honor, I didn't have a chance. I could only briefly look at the affidavit. Does the just want to see if the affidavit mentioned the. Doesn't.
If it mentions what?
The underlying charges that caused him to have to be registered. And frankly, Your Honor, I think the court should be aware.
Yes, it does.
Oh, it does? Okay. And just so the court's aware, he was sentenced to 20 years in state prison on those charges. Your Honor, if I may,
yes.
The warrant, well, I just need to check something. Okay, I'll leave it at that. Nothing further, Judge.
Okay.
Judge, at this time, nothing to add by the defense.
All right. I will impose a bond of $2,500 with, and that will be with a level 2 GPS. Arthur Washington.
Mr. Washington, come on up, please.
All right, Mr. Washington, you're before the court for count 1, premeditated murder. Counts 2, 3, 4, and 5 are violation of felony probation. The violation of probation matters are no bond hold, and I do find probable cause as to count 1. I will hear from the parties as to bond on count 1.
Your Honor, on one moment. On the top count, the state would be seeking no bond hold upon a finding of proof evident or presumption great for first appearance purposes only, again relying upon the arrest warrant and affidavit prepared by Detective Thomas of the Fort Lauderdale Police Department and signed by Judge Dennis Bailey.
In light of the fact that Mr. Washington is currently being held no bond on other matters, we will defer any argument regarding proof evident presumption great until such time as he can appear in front of his division judge. That being said, at this time we are invoking Mr. Washington's Fifth Amendment right to remain silent. We're instructing the state and all law enforcement officers and agents that they are not to attempt to contact Mr. Washington or speak with him about this or any other matter without first contacting his attorney. Mr. Washington, I'm advising you, sir, to not discuss this case with anyone but your lawyer. Don't discuss it with anyone in the jail. Don't discuss it with anyone on the phone. They are listening to your phone conversations, and they are recording them, and they will be used against you later. Do you understand?
Yes, sir.
Okay, I will also make a further preliminary finding of proof evident, presumption great, and Mr. Washington will be held no bond until any further order of the court. Good luck, sir. Adeline Syriac.
He's approaching, Judge.
All right, sir, you're before the court for one count of distributing or delivering heroin, and count two is a felony capious matter. That's a no bond hold, not for magistrate. You will be before your judge tomorrow at 8:30. I do find probable cause as to count one. The bond imposed there is $2,500, and I will leave that bond in place. Kenyatta Flynn?
He's approaching, Judge. He declined the service of public defender.
Hello. Afternoon.
Good morning, Mr. Flynn. Mr. Flynn, do you have a private attorney?
Not as yet.
All right, and so you wish to proceed this morning with these proceedings without the public defender's services?
That's correct.
All right. Mr. Flynn, you're before the court this morning for one count of robbery with a weapon. The court does find probable cause. And do you wish to say anything in regards to your setting your bond?
Yes. It was yesterday that I found out I got a woman after getting picked up at the airport by the sheriff department. Just coming back from international flight, and outside they told me I have a woman.
Okay.
So I was unaware that I had a woman. Also, I'm currently taking care of like my siblings as well as my mom. So when it comes to bond wise, I make about $1,600 a month, and about $1,300 of that goes towards strictly bills, not including food or gas. So if we can work something out, that would be great. Especially the fact that I was unaware that anything was happening. This is like a 3-year-old case, and I was unaware of that.
Okay.
Your Honor, I believe you set the bond for his co-defendant at $10,000.
I'm sorry?
I set the bond for his co-defendant at what?
I believe on this count for $10,000.
Okay.
On the first-degree felony. I've been requesting that Your Honor set it at the same amount, order of no victim contact.
What kind of priors does Mr. Flynn have?
I see no history, Judge.
Okay.
Ma'am?
Yes, sir.
We didn't have no history, no awareness, and when I spoke to the detective, they had no evidence based on what he's stating. It's just based on he say, she say until we get to court. Why would I have to pay bond if everything is stacked against me? There's no record of anything as of yet.
Well, that's why you need to talk to an attorney, Mr. Flynn. I can't give you any advice. The only thing I can tell you at this time is that I do find probable cause as to this charge, robbery with a weapon, and I am going to impose a bond of $10,000.
I think that's unfair, ma'am. I don't want to dig my dish here, but again, if I knew I had to go to court before, I would have went to court before. It's a 3-year-old case that I just found out I got a woman yesterday when they picked me up. There's no letter sent to my house. There's no phone call sent to me. I have not been hired and worked at my job for the past 6 years. So you know where to find me.
Okay, sir.
For the past 6 years, same residence. So I don't understand why is it that I was uninformed about any of this.
All right, sir. You may need to hire an attorney to be able to help you through this matter. James Underwood. James Underwood.
I think he's a medical lien judge.
Yes.
He's a medical reset?
Yes, ma'am.
That's crazy, dog. They over went on.
Lovinson Chevalon.
Mr. Chevalon is approaching, Judge.
Mr. Chevalon, you're before the court for one count of possession with intent to sell or manufacture deliver cannabis. Count 2 is possession of cannabis over 20 grams. Count 3 is possession of drug paraphernalia. Count 4 is robbery by sudden snatching without a firearm or weapon. And count 5 is contributing to the delinquency of a dependency. or a minor. All right, I do find probable causes to all counts. All right, that's the bond.
Your Honor, based on the nature of the offense, I'd be requesting a $5,000, a $3,500 bond on count 4, order no victim contact.
Okay. All right, Mr. Ryan.
Yes, Judge, thank you. I'm going to be requesting a $1,000 bond on count 4 and an ROR on count 3. Mr. Chevlon is 18 years old. Right now he's working. He works as a handyman. He's been doing that since November. He works, he lives in Lauderdale Lakes with his mother. His mother works at a restaurant. That's who he's going to be reaching out to post his monetary bond. And that's what we're requesting the amount we are. I believe he has very limited contact with the criminal justice system. So I believe a total bond, if my math is correct, would be $3,500 would be reasonable.
All right, I'm going to, I find probable cause. I am going to impose a bond of $2,000 on count 4. I will ROR him on count 3, but he's also going to be on level 2 GPS pre-trial. No victim contact. All right, so 1,000 on 1, 1,000 on 2, ROR on 3, 2,000 on 4, and it's 500 on count 5. Level 2 GPS and no victim contact. Good luck. Christopher Davis.
He's here, present, Judge Amin.
I know. Thanks. Got it.
Mr. Davis is before the court for 1 count of burglary of an unoccupied conveyance. Count 2 is possession of cannabis 20 grams or less. Count 3 is possession of burglary tools with intent to use. Count 4 is driving while license suspended. Count 5 is felony violation of probation. Count 6 is also felony violation of probation. Counts 5 and 6 are no bond holds.
Your Honor,
Yes.
count 5.
5?
On count 5, it's on a warrantless arrest, warrantless VOP. I'd ask the court to make a finding of no probable cause and ROR on that count.
Okay.
I spoke with confinement status and checked and reviewed. His probation was revoked in that case by Judge Scheer in June of 2018. He served a jail sentence and had his probation revoked. Okay. I checked in Odyssey, and it confirms that as well. And yeah, so
All right, so there'll be no probable cause on count 5, and he'll be ROR'd on that count. I do find probable cause as to the other counts, as the parties wish to be heard as to
Judge,
bond.
I think count 1 looks more like an attempted burglary to me.
that's fine, Judge.
Okay. So I'll make a finding for attempted burglary. One. Okay, as to bond? Any arguments?
Your Honor, based on the circumstances, I'd be asking for a $1,500 bond on count one.
Judge, I'm going to be asking, Mr. Davis is also, I advise him, as far as what the state said in reference to count 5, and he verified that. He said he did a jail sentence and his probation was terminated, but what we're inquiring is count 6 still reflects the probation no bond hold.
Yes.
And he's telling me that he's not on probation anywhere else, so I don't know where that stemmed from.
All right. There is, that's another state, that's out of state, right?
Do you know what state, Judge?
It looks like South Dakota.
South Dakota. All right, so on count 1, I'm going to impose a bond of $1,000. And then the bonds on the other, the standard bonds will remain on the other counts. Okay, good luck, sir. Brandon Hudson. Mr. Hudson, you're before the court for burglary of an unoccupied conveyance. I do find probable cause.
I would make the same argument for Mr. Hudson that I did for Mr. Davis, Your Honor, that it's an attempt.
Except that I'm seeing that they were in and out of the vehicle. That's what he observed him in the front seat, and he got out, and
Okay. He said he saw him. One moment. Yeah, it appears that Mr. Hudson was acting, according to the report, was acting as a lookout. So it would be an attempt, Your Honor.
All right.
I would ask to be heard on bond.
All right, I'll make a finding for attempted burglary, and I'll hear as to bond.
Thank you, Your Honor. Your Honor, I'm going to be requesting a $7,500 bond based on his criminal history. In 2013, out of Broward, he was convicted of burglary of a dwelling and grand theft between $20,000 and $100,000. He was sentenced to 45 months state prison as a habitual offender. He was released from state prison February 21st of 2017. All right, I'll get to it. Additionally, out of Broward, he has resisting without violence. He's gone to prison, 03, delivery of cocaine, grand theft auto, possession of cocaine, out of the state of Georgia. And I'm showing these cases have not been resolved. 2018, theft by receiving stolen property, financial transaction card theft, and theft by bringing stolen property into the state.
And Mr. Romero?
Judge, what I'm going to be asking the court to consider on this attempted burglary, which is a third degree, I'm going to be asking for $1,000 bond. Right now, Mr. Hudson, he is working. He works at a car wash. He lives with his grandmother. His grandmother is elderly and sick, and Mr. Hudson helps his grandmother. Right now, his 1-year-old daughter is living with them, so his 1-year-old daughter is with his grandmother. Judge, he does not believe that his grandmother has very much financial resources. She's probably barely going to be able to afford the $1,000 bond. My understanding, yes, he does have priors, but I believe the most recent was about a year ago. So, Judge, I'm asking for $1,000 bond on Mr. Hudson's behalf based on everything.
All right, I will impose a $1,000 bond with standard pretrial supervision.
So sir, I have to give you the math. As soon as you bond out, you have to report to pretrial. So within 24 hours of being released or someone posts your bond, you have to go there and there's the jail, you walk through, or right there. Don't report, there's a warrant issued for your arrest. Good luck, sir.
All right, do we have Dermel Grahai today?
Yes, Judge. He's here.
All right, what is it? It appears that we already found probable cause on Mr. Grahai. And so we just need to talk about bond today.
Your Honor, just based on the amounts involved in this matter, I'm going to be requesting, and these are filed charges involving 2 separate second-degree felonies, one for grand theft between $20,000 and $100,000, and then organized fraud in second degree. I'm going to be asking that the bonds be kept in place. Mr. Grahai could see Judge Fine that a more thorough, in-depth bond hearing could be had if the defense so wishes. To be frank, I don't know why an arraignment hasn't been set. This capias was served 2 weeks ago, and even if he was on loan,
right, there were several resets, and
even without having the first appearance, an arraignment could have been set in front of Judge Fine.
Mm-hmm.
I don't know why it wasn't.
Judge, I'm going to be asking for the court to consider releasing Mr. Grahai on pretrial release. From what I can see from these case numbers, there are 2017 cases. He lives in Miami. He's not working. From what he advised me, he has no funds, no property. There's no one that can afford any sort of monetary bond. So, Judge, I'm asking, considering the age of these cases, to consider releasing Mr. Grahai on standard pretrial release.
All right. Based on the nature of the charges, I am going to leave the bonds in place, and Mr. Grahai will go to his division. It looks like he has a hearing tomorrow. Great. So tomorrow he'll be before his division judge. Jesse McNair. Yeah. Let's see. Okay. We found probable cause. He just needs to come back for bond. And then Bradley Vaughn. All right, Mr. Vaughn.
Judge, here's Mr. Vaughn.
Yeah. Mr. Vaughn is before the court for 1 count of possession of cocaine, and count 2 is possession of cannabis 20 grams or less. I do find probable cause.
Judge, we're going to be requesting on Mr. Vaughn's behalf on this nonviolent offense if the court would consider releasing him ROR or ROR to pretrial release.
Okay.
So far, Your Honor, in the past couple years, I see 5 times he's been arrested on a capious warrant for failing to appear in court.
Judge, the only thing Mr. Vaughn is telling me is that they weren't felony offenses. They were all minor, I believe, municipal order. Correct, Judge. Nothing of a serious nature. He will be coming back to court.
I will come to court.
He will abide by whatever court order this court deems appropriate. But right now, there's nobody going to be able to afford to post his bond.
I just want to try to understand this. So is it being argued that Mr. Vaughn only comes to court when it's something serious? When it's not, nah, no reason to.
Never had a serious charge in
The point is, Judge, I'm trying to make, and Mr. Vaughn's trying to make, his priors do not include serious offenses.
I never had a felony here.
All right, Mr. Vaughn, I am going to release you to pretrial supervision. You need to, Mr. Romero is going to give you the information.
Yes.
As soon as you're released, sir, you need to go to the pretrial office.
Yes,
you need
please.
to sign up with them. If you fail to report or you violate any of
Right,
the...
I'm got warrant.
I'm also going to order that there be random testing. All right. All right.
Good luck, sir.
Good luck, sir.
What's that? It all depends. Okay, here's all the second look stuff.
Okay. You'll write the that he's got pre-trial. On McNair, you know, I signed it already. It's just that they keep bringing them back. Because this one was signed, on Monday. So do I need to?
I'll just take off the top one.
Okay. All right. Because I think I noticed that. All right, everyone. I'll see you this afternoon.